Hello, my name is Mitchell Proner. I am a personal injury trial lawyer here in New York. I have been practicing since 1988, which gives me over 30 years experience in this field. I have lectured to attorney groups across the country and in Europe. I was elected president of the New York State Academy of Trial Lawyers, which is the largest state trial bar in the country. I was lead counsel for the Costa Concordia shipwreck and off the coast of Italy, which gives me the experience of representing clients throughout the globe. And I'm considered an experienced trial lawyer. Tonight's topic is, what is my car accident case worth? And that's one of the first things people want to know after an accident. Typically, accident happens, they're injured, they go to a hospital, they might not go to the hospital, they might decline an ambulance, then the next day feel lousy and start to look for a doctor. But sooner or later, they want to know if they have a case and what it might be worth. And even if somebody has a case that's been going on for years, a lot of times their attorneys won't discuss with them what the case is worth, or they're wondering what the case is worth. So I'm going to explain the different amounts that different cases might be worth. And if you or somebody you know or a loved one is wondering what values are on these issues, hopefully it will provide you with some guidance. First of all, there are typically three factors that go into what a case is worth. First of all, how the accident happened. If somebody is 100% at fault for causing their own injuries, for example, somebody's driving along and they drop their cell phone while they're trying to text someone, and they bend down to pick up the cell phone and they accidentally turn the steering wheel and drive into a wall, they might sustain tremendous injuries, serious injuries, life-threatening injuries, catastrophic injuries, but their case has very little value in a lawsuit because there is no party that they can blame for being at fault for the accident other than themselves. Now, if somebody's a passenger in that vehicle, then they can point to the driver and you can blame someone for it. You can say somebody else is at fault. The legal term that we use for being at fault, and the same term is used in insurance policies, is typically liability. When a case goes to trial, depending on the jurisdiction, the judges instruct the jury on the law before a jury makes a decision on value. And typically, you have to prove two things to prove liability or fault. And that is whether or not the defendant, their actions were a significant factor in causing the injuries. It doesn't have to be the significant factor, meaning it doesn't have to be the only factor, but it has to be a significant factor. And secondly, whether or not the injuries were caused by the defendant's conduct. You need causation. Once you have liability and you can point to someone as being at fault for the car accident, the second thing is you need to prove under New York law a serious injury. Now, the serious injury threshold isn't something that is just some term that I use for my office when I'm trying to see if a case is something that we can help somebody out with or not. It's actually codified in the law. Section 5102 of the insurance law is called commonly the no-fault law. And according to the no-fault law, for every vehicle, there has to be a minimum of $50,000 in first-party benefits available for all motor vehicle accidents in New York State, with the exception of motorcycle accidents. Motorcycles are excluded under the no-fault law. And according to the no-fault law, if someone is involved in a motor vehicle incident with injuries, where there's a collision and someone gets hurt, they need medical attention, all the medical bills should be paid under the policy that covers the no fault. If you're in a vehicle, it's whoever insures that vehicle you're in. In New York, you need to have insurance to register a vehicle. In Florida, you don't need insurance to register a vehicle, but in New York, you need insurance. And your vehicle, when you register, you need proof of insurance, and you have to have $50,000 of no fault. Now, you could be hit in the rear while you're sitting at a stop sign, and the other vehicle behind you could be drunk and texting and be completely at fault. Your own coverage in your vehicle is going to cover for your medical bills and 80% of your lost earnings, up to $2,000 a month, and $25 a day in miscellaneous expenses if you need to pay for cabs because you can't use your car, or if you need to pay for somebody to clean your house because you can't do housekeeping, that can be under the $25 a day in miscellaneous expenses. Those bills will be paid by your own coverage. But in order to sue that vehicle behind you, where the driver hit you in the rear while they were drunk and texting, under New York law, it's not enough you weren't at fault, and it's not enough you went to the hospital. And it's not even enough you might be treating with a doctor. There is a serious injury threshold, and they have various categories: death, dismemberment, significant disfigurement, which is typically some sort of cut that leaves scarring, a fracture, 90 out of 180 days with a complete disability, or this two categories that the courts struggle with the most: significant limitation, permanent consequential limitation of a body system, function, or organ. Significant, permanent consequential, those two categories are most of the decisions by judges. And experienced attorneys, if they research the law, I actually gave a lecture to the Bar Association on this topic at least a dozen times all over the state for other attorneys for meeting their continuing legal education requirements. You'll find insurance carriers have contested whether or not you meet the threshold, and they'll even go up on appeal. And they do that sometimes on cases where there's shoulder surgeries and knee surgeries and back surgeries, and a gap in treatment, which under the law means you start going to a doctor and then you stop and then you go back to the doctor. That could be enough. Some judges have written decisions saying, well, with that gap in treatment, you might be out of a category and you might not have a case. So the categories are very important to determining, and the seriousness of your injury are very important to determining whether or not you're entitled to compensation, and then you could start to look at the value. So first part, liability, or who's at fault. Second part, do you have a serious injury for your car accident? And when I say car accident, that includes if you're a pedestrian and hit by a car. It includes if you're a passenger on a bus. Some decisions have included getting in and out of your car, because the no-fault law applies to the use and operation of a vehicle. Assuming we meet somebody else at fault, a significant factor, doesn't have to be the only factor. You have a serious injury under the law, maybe a fracture, could just be a fractured finger, but it's enough. The third part is, who's going to pay for it? And typically that's insurance. Now, as I mentioned, all vehicles require insurance, But the minimum policy in New York is $25,000. The $50,000 covers no fault. That's for your medical bills and 80% of your lost earnings up to $2,000 a month. That's apart. It's a separate coverage. But getting compensation from the vehicle that you're blaming for the incident, no matter how great a lawyer you have, if it's an individual with no assets, the only thing they own to their name is their car. That's all they own. And the car might be a 30-year-old car. And they rent their apartment. They've got no money in the bank. Their employment is spotty. They pay their bills late, but they kept the car on the road. And all they have is a minimum policy. Well, that person can cause a lot of damage with that 30-year-old vehicle. But even if the person driving that 30-year-old vehicle is 100% at fault for the incident, and the insurance company could be a well-funded insurance company like Allstate or State Farm or Geico or Chubb, plenty of assets, the insurance carrier only has to pay up to $25,000. And you can sue that individual personally, but the court costs are going to add up. And at the end, that person might not be able to satisfy any judgment over that initial $25,000. So you could have culpable conduct. You could have terrible injuries, but the case might only be worth that $25,000 because of limited insurance. Now, other vehicles on the road have much larger policies. The next level up is typically $100,000, then $300,000. Then you might find Uber and Lyft vehicles with over $1 million in coverage. But their coverage often is determined by whether or not the app is active. Lyft and Uber are ride-share apps. And if the driver has a car where he's an Uber driver, but he doesn't have the ride-share app active, he might not have that coverage available over $1 million. Of course, if it's a vehicle like a truck that's owned by Pepsi-Cola, it's unlimited coverage. Or if it's a municipal vehicle, like a garbage truck, it's unlimited coverage. But those are the three factors. So assuming that there's sufficient coverage and the other vehicle is at fault, assuming there is sufficient coverage and the other vehicle is at fault and you have injuries, what are those injuries worth? Well, in a personal injury lawsuit, you have to know the items of damages you're entitled to if you have a serious injury. You're entitled to past medical bills and future medical bills. You're entitled to past lost earnings and future lost earnings. You're entitled to past pain and suffering and future pain and suffering. Well, if your past medical bills and your past loss of earnings have been paid by insurance and the case goes to trial, you would still be allowed to present all the bills and all your lost earnings to a jury. But typically there would be a collateral source hearing, and the collateral source hearing is after the jury comes back with a verdict. The judge has a separate hearing where he says what was already paid and you don't get that money. But you still would be entitled to your future damages, your future loss of earnings, and your future medical expenses if you could present proof that you're entitled to them. So in order to present that proof, first of all, you need a doctor that would say your injuries are permanent or have some degree of permanency so that it's going to affect your earnings in the future and it's going to affect your need for medical care in the future. Then you're entitled to those damages. So if you have that permanency to your injuries that affect your ability to earn and your need for medical care, that could increase the value of your case. Another item that might increase the value of your case is your pain and suffering. Typically, if you have limited treatment, you have limited pain and suffering. So if you broke your finger and you went to the doctor for 6 weeks and then you stopped treating, your case would be a serious injury under the threshold because you have the broken bone. It's a fracture. A fracture is a broken bone. It's the same term under the law. A fracture, broken bone, it meets the threshold. But 6 weeks for a broken finger or 6 weeks for one broken rib, if you don't go back to the doctors, you're not going to have permanency, and the case is not going to be worth more than perhaps 20 grand. Depending, of course, on the severity of the fracture and any limitations of motion or strength that you might have that are residual, but then you're getting back to permanency. And you need to treat with a doctor, usually for at least 4 to 6 months before he can determine any permanency to your injuries. Once you have permanency, the case can be worth significantly more. If you have a surgery, the type of surgery and the seriousness of the procedure can dramatically increase the value of a case. Now, because juries award more money for these types of cases with surgeries, with permanency, insurance carriers, in trying to evaluate what a case might be worth, will take that into consideration and typically have a larger offer. The last item is, I think over time, the experience and reputation of the attorney can affect the value of a claim. I know personally that as I've gotten older and I've gotten more experience, it's gotten a lot easier to get larger numbers on cases because my adversaries and the insurance carriers know that I try cases, that I take verdicts. I've tried cases in over 30 different jurisdictions in multiple states. I've taken multi-million-dollar verdicts, and I've had multi-million-dollar results for my clients every year for the last 30 years. So it's gotten easier for me to get those larger numbers. That's not to say a young lawyer can't be a great attorney and can't get you full value on your case, but I think the experience and reputation of an attorney can affect the value of a case and how much the insurance carriers are willing to put up on a case. And all those items typically tend to go into evaluating the value of a case. With regard to how somebody can increase the compensation on a case. Hi, Luis Carlos. How can they know that I was texting? It's up on the screen right now, so I know you're texting. I couldn't read it without my glasses on. With regard to increasing the compensation that somebody's entitled to on a case, someone can increase the value of compensation by getting medical care. Now, if you're fine, if you feel great, there's no point in going to a doctor for your injuries. You're going to go to the doctor and you're going to say, I feel great. And the doctor's going to say, glad to hear it. He's going to write it down. He's not going to do anything for you, or she's not going to do anything for you. If you don't have symptoms, no doctor is going to say, well, you feel great. Let's give you some medication, put you in more therapy, get you surgery. They're just not going to. But if you have symptoms, two things happen. Number one, the doctor can typically prescribe some sort of treatment or medication. I might even say just wait. But they typically have treatment that they can give you or prescribe for you that can hopefully make you feel better, because your health is more important than any money you're going to get on a case. But the second thing they do is they write it down. And in every case that involves personal injuries, the medical records are the proof that documents your injury, and that's what is used to increase the value of your case. So sometimes people go to the doctor and they want to be like in the movies, he's a strong guy. No, doc, I feel good. I'm not going to complain. There's no point in going to the doctor to not complain about what bothers you. You're not letting the doctor do their job. But if you go to the doctor and you tell them what bothers you, you don't need to make up complaints. That's insurance fraud. And it's no point in trying to make your money with insurance fraud. You're better off getting a job if you're healthy. But if you have the injuries, you tell the doctor, maybe they can make you feel better, and your case becomes worth more because your lawyer has proof that he can send to the adjuster to try and get you a better offer. And if you can't get a better offer, he can use that proof by introducing it at trial. Now, if the insurance company doesn't have enough coverage to cover your medical expenses, typically, no fault is a $50,000 policy to cover your medical expenses. But a lot of times that gets exhausted. If there's sufficient money on the policy for the vehicle that's at fault, typically you can get a doctor to take a lien, meaning they'll get paid at the end of the case. And oftentimes your lawyer can provide you funding. It's at a much higher interest rate, so it's not recommended if you have other insurance or other means to pay for it. But you could get, if you have no other means, a lawyer might be able to get you funding to pay for a surgery if it's necessary. And that can also increase the value of a case. And if the insurance coverage is not there to cover your medical expenses, that's a consideration. Now, if you're partially at fault for an injury, you can still be compensated in New York. New York is a strict comparative negligence state, which means if you're 20% at fault, you still get 80% of your damages. If you're 50% at fault, you still get 50% of your damages. If you're 80% at fault, you still get 20% of your damages. In other states, for example, Connecticut, you got to show the other vehicle is more than 50% at fault. That's a modified comparative. Some states, they can't be at fault at all. Like Maryland, I believe, is a strict contributory negligence state. But New York is a strict comparative negligence state, so the other side could still be partially at fault, and you could be partially at fault and still get compensation. Does it matter where the accident happened in New York? It can. Places of venue, where you live, where the other vehicle owner lives, where the other vehicle driver lives, and where an accident happened can change where your lawyer could file suit. And jurors in some counties pay more than others. That's not to say every case is worth a certain amount in a certain county, or you can't get a lot of money in other counties, but where your accident happened could affect the value. Typically, upstate cases, they pay less money on than cases in the city. That's not to say I haven't had multi-million-dollar case upstate. I have. It's just I've had cases in Wayne County up by Rochester, and Erie County by Buffalo, in Albany, and Broome County, Binghamton. I've had cases all over. But typically, cases in the city pay more than they do in Long Island. That's not to say. I've gotten multi-million-dollar verdicts everywhere. But that could change the value of the case. So these items come into consideration. If you're looking to find out the real value of your case, the best thing to do is to consult with an experienced attorney. To consult with my office, I've got a team of investigators, paralegals, associates, and of course, you can always speak directly with me if that's your desire. We're at 1-800-321-1234, and to consult is always confidential and free. Most importantly, I hope you don't have a case and you enjoy your health, because your health is more important than any money we can get you. I hope this answers some of your questions, and wish you the best.
I live in Manhattan. It was a rear-end collision. Yeah, I was driving straight and came to an immediate stop, and the guy behind me just came and smashed into me. At the moment, I felt a little bit scared, nervous, and yeah, I just didn't know what to do. And then I got out the car and I immediately felt the pain and went back in. My concern, like I felt upset at the moment because it was my way of getting home, transportation. Yes, I was concerned about my family because, like I said, it was the way of me getting to work, and then I didn't have a way to get to work. The reason why I wanted to get an attorney was because I didn't know how to deal with this it was my first time being in a car accident, and I didn't know what to do afterwards. I found Prono and Prono, it was recommended to me by my brother. The work of Prono and Prono was very good. They helped me out to the max. The legal process, it was explained to me perfectly. Once I gave them a call, they told me what to do afterwards. They set me up with physical therapy. They guided me with all the steps needed. I would definitely recommend Prono and Prono.